Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. So today, I am Haziq Fikri bin Zaimi together with my partner Abdul Hanif. We'll be presenting case review on the case named Elms and Ansell Limited 2007. A little bit introduction to our case. The case is related with product liability law in South Wales. So the case was judged by Justice Malpass, specifically in the Supreme Court of New South Wales. So the main issue in this case is the interpretation and application of Part 5A on the liability for defective products of the Trade Practices Act 1974. So the parties in dispute where the plaintiff is a nurse who is working in South Eastern Sydney and Illawarra Area Health Service, and the defendant is the manufacturer and distributor of these latex gloves that was sold to the employer of the nurse. A little bit summary of the facts. So the plaintiff, who is the nurse that I was mentioned earlier, was regularly exposed to the latex products, including the latex gloves. So the claim was about the alleging injury on around October 20th of 2003 due to exposure to these gloves. So the plaintiff filed statements claiming for compensation under the cause of action of negligence under several sections under this Trade Practices Act. A claim under Section 75AD, 74B, and also Section 52 of the Act. However, the defendant subsequently filed a notice of motion on 6th of June 2007 seeking to strike out paragraph 7 until 9 of the statement of claim. So in this case, it is the notice of motion by the defendant to strike out paragraph 7 until 9 of the statement of the claim on the basis that sections does not apply to the situations. So therefore, the judge discussed in this case whether Section 75AD or Section 74B of Trade Practices Act 1974 provide any remedy to the plaintiff. So in order to decide on this main issue, the judge also discussed whether the plaintiff falls under the definition of consumer who acquires according to the definition in Trade Practices Act and is subject to the right of compensation. So in the first issue, whether Section 75AD or Section 74B of TPA provide any remedy to the plaintiff. So the court considered both of these cases that I've mentioned in the slide, Lanza Academo Management, that was affirmed by another case, Cleese and Browner Pty Ltd. So in this case, in the latest case, the 2002 case, the defendant applied to strike out this paragraph on the basis that Section 75AD does not apply on the face of the statement of claim. So it was argued that the result follows because of the existence of Section 75AI, which prohibit the section to be applied in this case. Section 75AI put a section on the compensation that is allowed to be claimed by the person who being injured with the defective products in Section 75AD. So the section reads, no liability action where workers' compensation or law giving effect to an international agreement applies. So in both of the cases, the judge decided that the plaintiff had already received compensation from the workers' compensation. Therefore, the Section 75AD does not apply in their situation. So similarly, into our case, the nurse had already received compensation from the employer. Therefore, Section 75AD do not apply in the current situation due to the exception in Section 75AI.
Moving on for the judgment for the second issue, on whether the plaintiff falls under the meaning of consumer who acquire, the defendant argued the plaintiff did not acquire the glove and the goods as they were not supplied to her within the definition of the Trade Practice Act. The judgment is that the plaintiff does not fall under that meaning and is not entitled for compensation under the Act. The court stated that the definition of acquire is inclusive but not exhaustive. The elements in the definition have a commonality or same characteristic, which is commercial activities, and if it does not fall under that commonality, then it is considered to be not included in the definition. Now, moving on to the comments and analysis for this case, I will be starting with analysis on the judgment on the case that was decided by the court. For Section 75AD, the claim under Section 75AD was struck out by the court. This is based on Section 75AI, which renders the plaintiff unable to claim under Section 75AD if the plaintiff is entitled to workers' compensation. The court relied on precedent from Lanza against Codemo Management Propriety Limited and Clis against Brownbill Propriety Limited to support the argument that Section 75AI provides a defense against claim where worker compensation is available. The court's reasoning is consistent with statutory interpretation and the existing case law, where Section 75AI explicitly provides a defense against claims for which workers' compensation is applicable, and by following this precedent, the court ensured judicial consistency, and the decision in Lanza and Clis reinforced the view that workers' compensation schemes are intended to be exclusive in providing remedies for workplace injuries, thus precluding additional claims under Section 75AD. Therefore, claim under Section 75AD shall fail. Now, for Section 74B, the court focused on the interpretation of acquire and supply within the context of Section 74B. It concluded that the plaintiff, by merely using gloves supplied by her employer, did not acquire the goods in a commercial sense as required by the Act, and the court emphasized the commercial nature of the transaction implied in the Act's definition and found that mere usage did not meet this criteria. And the court's interpretation of acquire aligns with a narrow, commercially oriented understanding of the term, whereby emphasizing the need for a commercial characteristic in the acquisition, the court maintained a consistent interpretation with the Act intention to regulate trade and commerce, and the inclusive definition of acquire in Section 4 of the Act supports the need for a transaction that are of the same element, which was absent in this case. After making thorough analysis of the case, there are some comments that can be made on the decision that was made by the court. Specifically, on ambiguous statement that was stated in the judgment, while definition of acquire, the court's interpretation of acquire was limited to commercial transaction. While this interpretation is reasonable, the inclusive nature of the definition suggests that it would suggest other form of acquisition beyond commercial context. So the court did not explore this potential meaning, which could lead to future litigation seeking to expand the interpretation. Another ambiguous statement that was made by the court was on the matter of consumer protection scope, where the court did not address whether employees using products that were supplied by their employers could ever be considered consumers under different circumstances. This leaves an open question of how far consumer protection extends within an employment context. Now, moving on to the effects on future decision of this case. The decision in Elms against Ansell Limited will set a precedent for a strict interpretation of acquisition and supply under the Trade Practice Act, particularly in workplace context, for cases that will have similar circumstances or similar facts of case. And it highlighted the exclusivity of workers' compensation scheme for workplace injuries and limiting employees' method for additional legal remedies against product manufacturers. This means that workers that were affected by the goods under a workplace environment, then they cannot claim under Trade Practice Act but must claim under workers' compensation. This shows that only person that is recognized or falls under the definition of the Act can carry out claims under the Act. If a person does not fall under that definition, then they must find other alternative to claim for compensation. Lastly, in comparison to the laws in Malaysia, under the Consumer Protection Act 1999, Section 68 provides for liability for defective products, where it is stated that where damage is caused wholly or partly by a defect in a product, the person who suffered the damage may claim for compensation and help the person that produced the goods to be liable. Damage is interpreted as death or personal injury, or any loss or damage to any property including land, and any person who suffered damage due to the defective product can claim under this provision. Under this provision, it was also stated that it is immaterial whether the supplier supplied the defective product to the person who suffered the damage or to producer of product that used the product, and also to any other person. The word any other person in this provision opens a wide interpretation as who can claim under this provision. And in comparison to the Trade Practice Act by the Australian, it does not mention any workers' compensation where any damage happens in the course of employment. As in regards to Trade Practice Act, they specifically mention that where workers' compensation is can be claimed, then they should claim under workers' compensation. However, the wording of supply under the Act interpreted the same as in Trade Practice Act. So, if it occurs in Malaysia, and if Malaysia were to follow the decision of this case, then the decision would be the same as case of Elms against Ansell. Therefore, to conclude, the court's reasoning in Elms against Ansell Limited is well supported by statutory language and precedent, and the decision maintains consistency in the application of the Trade Practice Act and workers' compensation law. However, the narrow interpretation of acquire could be subject to challenge in future cases, where they will widen the scope of consumer protection under employment context. And the decision highlights the importance of clear statutory definition and the potential need for legislative clarification to address ambiguities in consumer law. And lastly, it can also be a guideline in future Malaysian cases dealing with the same matter due to the similar interpretation. That is all from me and Haziq for the case review of Elms against Ansell Limited. Thank you.